Welcome back to the POAS Desk. In the last episode, we covered apostille and consular attestation. In this episode, we cover something more contentious.
What
happens when a POA's validity is challenged and how disputes are resolved? Most POAs are used cleanly. The principal grants authority. The attorney acts on it. The transaction completes. No dispute arises. But when something goes wrong, the POA itself can become the subject of a challenge. Understanding how challenges work helps you avoid being on the wrong side of one. There are several common scenarios where POAs are challenged. A principal claims their signature was forged or obtained under duress. They argue the POA was never validly issued. The attorney's actions under that POA are then questioned. A principal claims the attorney exceeded the authority granted. They argue that even if the POA was valid, the attorney did things the POA did not authorize. The specific transactions are challenged. A third party, often a buyer or counterparty in a transaction, challenges the POA's validity after the fact. They argue the document was not properly executed and seek to unwind the transaction. An heir or family member challenges a POA issued by a deceased person. They argue the POA was issued under questionable circumstances or that the principal lacked capacity at the time. A bank or other authority retroactively determines that a POA they accepted was actually invalid and seeks to reverse transactions. Each type of challenge has its own resolution path, and the path involves UAE courts. For challenges based on forgery or duress, the principal must file a formal complaint and provide evidence. UAE courts will investigate. If the claim is upheld, the POA is declared invalid from inception, and transactions executed under it can be reversed. The attorney may face criminal liability if forgery is proven. For challenges based on the attorney exceeding authority, the focus is on the specific powers granted versus the specific actions taken. The court reads the POA's wording carefully. If the action was within the wording, the attorney is protected. If the action was outside the wording, the attorney is liable for the unauthorized acts. For third-party challenges, the question is usually whether the third party reasonably relied on the POA's apparent validity. If the POA appeared valid on its face, properly notarized, properly translated with appropriate seals, the third party usually has protection. If there were red flags the third party ignored, they may bear some responsibility. For inheritance challenges, the question is the principal's capacity at the time of issuance. Did they have legal capacity? Were they under undue influence? Did they understand what they were signing? Medical evidence and witness testimony often matter here. For retroactive bank challenges, the bank's own due diligence is examined. Did the bank verify the OAA properly when accepting it? Did they follow their own procedures? Banks who skipped steps may be liable for resulting losses. How to protect yourself from being on the wrong side of a challenge. As a principal, keep records. Retain a copy of every POA you issue. Note the date, the attorney, the powers granted, and the validity. Period. If a payer needs to be revoked, do it formally and keep evidence. As an attorney, act within the four corners of the POA. Do not interpret the powers broadly. If something is borderline, ask the principal to confirm in writing or issue a more specific POA. Keep records of the transactions you execute, including the principal's instructions where available. As a third party, a counterparty in a transaction, verify the POA carefully. Check that it is properly notarized. Check that it specifically authorizes the action you're relying on. Check that it has not expired. Check the party's identification matches. Document your verification. As a family member of the principal, address concerns about a POA when you become aware of them, not later. If you suspect a POA was issued under duress or that the attorney is acting improperly, raise it through legal channels promptly. Delay can be interpreted as acceptance. A common scenario we handle. A property is sold under a POA. After the sale, an heir of the original principal challenges the validity of the POA, claiming the principal lacked capacity at the time. The buyer is now caught between the seller's heirs and the completed transaction. Resolution typically requires courts to examine the principal's capacity at the time the POA was issued, which involves medical records and witnesses. Another scenario. An attorney signs documents under a POA that has technically expired. The receiving authority did not catch the expiry. The transaction completed. Months later, the expiry is noticed, and the transaction's validity is questioned. Resolution involves whether the parties acted in good faith and whether a fresh, valid POA can be issued retroactively to ratify the actions taken. A third scenario. A POA is used after the principal's death without anyone realizing the principal had passed away. The transaction completes. When the death is discovered, the POA's validity is challenged because POAs end on the principal's death. Resolution involves whether anyone knew or should have known of the death at the time of the transaction. These scenarios are not common, but they are not unheard of. The cost of resolving them is high, in legal fees, in time, and in the human stress of a contested transaction. At POAS, we draft to minimize dispute risk. The document specifies powers precisely. The validity period is clear. The notarization is unambiguous. The translation is verified. We do not draft documents that try to do too much in one POA, because broad documents are easier to challenge than narrow ones. If a POA we drafted is later challenged, we provide our records and assist the principal as needed. The fixed fee includes this support within reason. We do not provide legal representation in court, that is for lawyers, but we provide the documentation and evidence relating to our drafting and notarization. In episode 30, we wrap the series with a capstone, the 5 most expensive POA mistakes and how to avoid them. I'm Patrick. Thanks for joining me at the POAS Desk.